Hearing in the appeals, Williams and the Supervisory Authority.
May it please your Lordships, I am here on behalf of the appellant, Mr Ahmed Williams, together with my learned friend, Dr David Dorset of the Bar of Antigua and Barbuda. The respondents are represented by my learned friend, Mr Justin Simon of Queen's Counsel of the Bar of Antigua and Ms Desiree Artesi.
May I ask Mr Taylor, has a statement of facts and issues been agreed in this case?
My Lord, a statement of facts and issues is included in the bundle.
Oh yes, we've read the one that's included, but we understood from the prefatory words that it wasn't agreed.
Perhaps Mr Simon can assist, but the message I had from his agent was that it had been agreed.
Is that right, Mr Simon?
Yes, my Lord. There was back and forth, I agree, but eventually there was...
Well, I'm very pleased to hear that, because Council should understand that a statement of facts and issues is not a preliminary bout in the adversarial contest between the parties. It is something that is designed to assist the court, and therefore it is the duty of counsel and solicitors to ensure that the court is given the assistance that the statement of facts and issues provides. So I'm very pleased to hear that it has been agreed. Thank you very much. Thank you. Yes, Mr Taylor.
My Lord, the Attorney General for Antigua and Barbuda was invited by the Registrar to intervene in this matter. Having checked with the Registrar this morning, nothing has been received, but I know Mr Simon wants to raise a preliminary point on that.
Right. Yes, Mr Simon.
Thank you. My Lords, I just need to indicate that I do not hold a brief for the Honourable Attorney General of Antigua and Barbuda.
Right.
And that our arguments will be limited to the constitutional issues as address the appellant, Ahmed Williams. But in terms of the general constitutional issue as to whether or not the legislation is constitutional or not, I do not have that wide scope.
I see.
To address this.
Well, thank you very much for making that clear. Thank you. Yes.
My Lord, if I could just reply in response to that, is that all the papers were served on the Attorney General. I corresponded with him, corresponded with counsel for the Attorney General last week asking if any representations would be put in. The constitutional issues that my learned friend refers to, what we say here is it's not the entire Act, it's the civil forfeiture order regime within that, and that applies directly to Mr Williams' appeal. So to the extent my learned friend can help or not, we say that is a relevant factor and it is a central issue. My Lord, this is an appeal from the decision of the Court of Appeal of the Eastern Caribbean, in effect upholding the civil forfeiture order made by the High Court. Can I say immediately that there's the Money Laundering Prevention Act, which is the centre of this appeal, in the bundle is an unofficial version. The reason behind that is that there is no official consolidated version, and this appears, the consolidated version in the bundle appears on the respondent's website, and it's been agreed between the parties that it is an accurate reflection of the amendments up to the relevant time. But we do have a bundle of the original Act and the subsequent amendments from the Antigua Law's website, if the board requires that.
Thank you very much.
One other house...
Has it changed since, or is it here printed as it was at the relevant time?
My Lord, it's printed as it was at the relevant time, and of course one of the points we take is that the subsequent amendment in 2014 really underlines the other grounds that we make, and that's dealt with in the supplementary.
I thought so, but I just wanted to make sure this isn't the current one.
No, it's a snapshot of the legislation relevant at the time. Well, there's one other housekeeping matter is that I've handed up this morning an extract from Crays, because my learned friends raise a number of issues of statutory interpretation, which I can perhaps take your lordships to later on. My lords, going to the appellant's case, paragraph 4 sets out the civil forfeiture regime that we take issue with. And paragraph 6 sets out the central issues. Whether the freeze order was validly granted and whether the civil forfeiture regime violates the constitutional safeguards in the various sections. My lords, to the extent that my learned friends raised the point about the validity of the freeze order not being argued below and being new ground, in fact, it was argued below, but it has been expanded upon before the board. If leave is needed to argue that point, then I would seek it, but I would simply say to your lordships that this is really an expanded version of the grounds argued below. Our primary submission is that the civil forfeiture regime is criminal in nature and therefore unconstitutional. But if the board is against us on that point, we say ground 1 stands, as well as the arguments within the constitutional section dealing with circularity, unclear language and the imprecision of the statute and the lack of redress. And if I can just point your lordships to paragraphs 123, 131 and 143 of the case, those are the parts that we say remain, even if your lordships would find this is a civil and not a criminal statute. In relation to ground 2, the battle lines between us and the respondents appear to be, from their case, that the respondents' response is based entirely on the assertion that this is a civil regime. They don't address the individual consequences that flow if the board finds that it is in fact criminal. And it may be because if that label is given to it as the reality of that regime, that the matters that flow from it are not contentious. If I may make 4 short points by way of introduction. Firstly is that the domestic and European courts have recognised that there's clearly a legitimate public interest in seeking to recover the fruits of the proceeds of crime, even where the legislation creates proceedings that involve reverse burdens, civil standards of proof and orders which can be draconian. However, the courts have also emphasised that they will give careful scrutiny to such legislation to determine, as Lord Steyn said in Resv, simply give your lordships the reference page 1589 at H, whether the regime is a precise, fair and proportionate response to the important need to protect the public. Second point is that we submit that it's clear that while it's possible to create a constitutionally compliant civil forfeiture regime, the CFO in the Money Laundering Prevention Act fails to meet that criteria. It lacks precision, it relies on unfair and unlawful procedures, not least that it's a civil court determining criminal offences, and it can result in arbitrary and disproportionate orders. And if I can give your lordships a little detail about the sentence in this case that this regime allowed. The purchase price of the drugs that Mr. Williams was convicted of having was just under $15,000, $14,776. The sentence he received was 5 years imprisonment, $100,000 fine, plus, under the forfeiture, all of the property in which he had an interest of $782,300 My Lord, we say that is wholly arbitrary and disproportionate to the aim of the legislation. The third point is that the model taken by the legislature in Antigua is a novel one. We say it's targeting the defendant rather than the property obtained by unlawful conduct. And it appears from the diligent research of my learned junior Dr. Dorset that this model is not used in any other civil forfeiture regime in the Caribbean or the UK. And we've set out in the supplementary skeleton the range of regimes in the Eastern Caribbean, but Dr. Dorset has also looked at the rest of the Caribbean, and there is no equivalent model. And we say that there's good reason for that, in that it's unconstitutional. And in fact, the introduction of the new civil recovery regime in Antigua in 2014, which in effect mirrors that of the Proceeds of Crime Act in this country, may well be indicative of that realisation by the legislature.
That is speculation, though.
My Lord, I accept that.
I mean, we can't really make a ruling based on what the legislature has later done.
My Lord, what I'd say in response to that is that it's noteworthy to the extent that the comments by the Attorney General, who rather unusually represented Mr. Williams at one of the earlier hearings, in the guide, which I quote in the supplemental case, does seem to suggest strong indications that this is the first time such civil recovery has been brought in. And the Money Laundering Prevention Act that we complain about has not been repealed.
But there was a poker, wasn't there, in Antigua before?
There was. It related to criminal proceedings only.
It was only criminal proceedings. But I won't take you out of your
My Lord, I will come to that if I may shortly.
your routine now.
Okay. And finally, the fourth point I'd make in introduction is that the matters raised in these two grounds are not mere technical complaints. They go to the heart of the civil forfeiture order made against Mr. Williams. And this is not analogous in our submission to a criminal appeal in which the board finds there's material irregularity but decides to apply the proviso because the other evidence is overwhelming. These grounds identify firstly a significantly flawed application and then the granting of the freeze order, and secondly a regime that is so fundamentally flawed it can't be upheld as a lawful process. My Lord, with those introductory remarks, I would invite your Lordship to allow me to deal with the matters in this way, and it's taking the case slightly out of the sequence in the written submissions, is to expand on the various the submissions relating to the various civil and criminal proceeds of crime regimes, and then to deal with the fact that it's criminal and not civil, and then put the two grounds within that context.
Yes, of course.
Thank you, my Lord. My Lord, if I can take Lordships to section D of the case, page 784, and it's paragraph 24. And the reason that we say that it's essential to look at the various forfeiture and confiscation regimes, not just in Antigua and Barbuda, but in the UK as well, is because both the respondents and the Court of Appeal placed reliance on those to argue and to find that this was a civil and not criminal regime. And in fact, the Court of Appeal, the judge there said, I place heavy reliance on Walsh and Director of Asset Recovery Agency, which, of course, was my Lord Kerr's case. We say that these are fundamental errors because the authorities that are relied upon relate to wholly different forfeiture and confiscation regimes, and they simply can't be compared to the novel approach, as I call it, in Antigua. My lords, there are in effect two forms that we say constitutional compliant legislation can take in this area. There is the criminal confiscation, and that applies to a convicted defendant. It's an extension and a continuing part of the criminal procedure, and it's triggered by conviction for a specific offence. My lord, at 789, page 789 in the case, paragraph 46, it's encapsulated there by the words of Lord Phillips in Gale, that the civil regime under POCA, UK, is designed to prevent the enjoyment of the fruit of criminal activity. It focuses on the criminal. And because of the danger of arbitrary and disproportionate results from applying that criminal regime, there are inbuilt safeguards into, as far as we can tell, all of the equivalent legislation, both in the UK and in the Caribbean. And if I can just take your lordships to page 791, paragraph 55. It's what we call the safeguard.
791.
Paragraph 55, my lord.
I'm sorry, I don't have a paragraph 55 on
I'm sorry.
It's 56, I think. Paragraph 55 is just the heading.
Yes, paragraph 56.
Yes, thank you.
So under section 10, the court must consider whether there's a serious, real risk of injustice if the confiscation order is made to its fullest extent. And as Lord Bingham said in Mackintosh, the court must act with scrupulous fairness in making its assessment to ensure that neither the accused nor any third party suffers injustice. And that has been recognised as one of the factors by the European Court and indeed by the domestic courts to justify the regimes that have been in place thus far. There is a similar safeguard in the Proceeds of Crime Act in Antigua. And, my lords, I set that out, page 788, paragraph 43. Of course, this relates purely to criminal matters, but it talks about at sea the hardship that may be reasonably expected to be caused. And that is a factor which, as I say, exists in all of the regimes we looked at in the Eastern Caribbean. And indeed, as your lordships know, in Wales, after the Supreme Court's approach to the question of proportionality and the risk of injustice, that the Proceeds of Crime Act was amended to introduce an overriding requirement of proportionality. So, my lord, that's the first approach that we say would be constitutionally compliant. Of course, the CFO regime in Antigua contains no safeguards of that nature. It is, in effect, what we say is equivalent to a mandatory sentence once the criteria is fulfilled, and there's no ability to adjust the amount of the order up or down. Now, my learned friends in their submissions refer to ancillary orders in section 19B of the Act, which allows the court to make orders connected with the freeze order. My lords, perhaps I can just take you there. It's page 943 of the core bundle. My learned friends rely on this to say that these are the safeguards embedded in the regime to meet our complaints. But in fact, when one reads it, it's related entirely to the making of the freeze order and not the...
Well, that's true, but then the forfeiture cannot be of anything which is not at the moment when the forfeiture would take effect within the freeze order. So it has, doesn't it, a sort of knock-on consequence in terms of what can be forfeited.
Well, except, my lord, if one turns back to the section 19,
Yeah.
Once the criteria, this is page 936 and 937, once the criteria in A, B or C, or we say A or B or C, is fulfilled, and that the court satisfied that there is property in which the defendant has an interest, all of that property falls within the freeze order. So that there's no ability, we say, within at that point to adjust it. And in fact, it's a very early stage. It's the section 20A later on requires the court to make findings in relation to money laundering activity within the last 6 years. So that's really the final stage.
Yes, but Lord Briggs's point remains that one has to look to see what is in the freezing order, to see what can be forfeited.
That's 20A.
You can't, a civil forfeiture order cannot extend property which isn't subject to a freezing order.
My lord, yes, indeed.
Well, that is the point.
My
Lord
lord,
Briggs
yes.
is
So I think
20A1 on page 951, and what's more, the way it's worded enables you to make any application to take property freeze under section 19, right up until the moment when the freezing order takes effect. So, for example, during the hearing of the forfeiture proceedings.
Well, my lord, the freeze order's taken place as soon as the court orders it.
Yes,
It's under section 19.
But then under section 19 you can apply to take property out. So you've inherited it.
You can, my lord, with respect, it doesn't deal with the safeguards because there's two parts of the regime. The first is that this is, according to the respondents, this is an act which seeks to deal with the fruits of offending. The way in which the Act should do this, I say, in relation to civil forfeiture proceedings generally, is to consider the culpability of the defendant and the extent to which he has benefited from the fruits of his crime. Now, the difficulty here is not that he can't argue that, in fact, there's a legitimate reason for the property that he has which isn't related to the crime. It's that once they've rejected that, all of his property goes. And there's no ability to say, as in some of the cases, I mean, my lords, can I perhaps give you an extreme example? A defendant has $100 worth of drugs which is found on him. That falls within the money laundering legislation. He has inherited property, this was the first offence, and he inherited property 40 years beforehand, or is unable to show how he legitimately purchased it. His property is worth $1 million. Well, my lord, on that basis, it doesn't help him that section 19 allows him to adjust the property. That £1 million worth of interest will be taken. There's no proportionality and there's no safeguard to avoid that. It's the latter part, the actual framing of the amount of the confiscation order. And of course, in Ware, there are a number of examples that are given of where, for example, the defendant has paid back the monies that were stolen, or that they were incredibly small amounts. My lords, if I can give you the actual reference to the part in Ware, but there's two cases, Shabir and Morgan, which are referred to at page 1673, paragraph 17. And those are the sorts of cases that the Supreme Court was concerned simply led to disproportionate orders. And it's this fundamental safeguard to ensure that there is proportionality between the offending, the benefits of the crime, and the order that we say is one of the major problems and violations of the Constitution. The ancillary provisions in Section 90 do not provide for that safeguard in our submission. My Lords, the second constitutionally acceptable compliant regime is the civil recovery and forfeiture order, which the respondents say this is. And that is where the recovery of the unlawful proceeds of crime, and as it was put in Gale by Lord Phillips, again, it's the fruits of the crime themselves. And this is the sort of the in rem and argument as opposed to the in personam argument. You do not need, in order to make a civil recovery order under POCA or any of the other civil legislation, you do not need a defendant. You do not need to identify the defendant. And my Lords, it's set out perhaps best in my submission, page 790, paragraph 54, Smith, Owen and Bodner. The most important characteristic is that they're claims to property rather than individual, and then at B, proven misconduct on the defendant is irrelevant if the property which is subject to the claim cannot be shown to be derived from that conduct, while exonerating the character of the defendant will be irrelevant if it's shown he obtained the property in question from someone who in turn obtained it through crime. The focus is on the property rather than the individual. And my Lord, the difficulty for the respondents in my submission in saying that this is of that nature is that unlike any of the other civil recovery legislation, this requires a trigger, which is to find that the defendant has committed specific offences. My Lords, under POCA, and if I can, UK, if I can take your Lordships to page 242, which is at page, section 242 at paragraph 1086. It's the bottom of that page, 242. A person obtains property through unlawful conduct, whether his conduct or another's, if he obtains property by or in return for that conduct. And then over the page 2b, it is not necessary to show that the conduct was of a particular kind if it is shown that the property was obtained through conduct of one of a number of kinds, each of which would have been unlawful conduct. And unlawful conduct at page 1085, section 241, is exceptionally wide-ranging. It's in effect any criminal offence. Whereas, of course, in our regime, it has to be a specific list of offences. My Lord,
Sorry, but if it has to be a specific list of offences, why isn't that better for the defendant? It's more of a protection.
Because it requires the determination of a criminal offence by a civil court, which is unlawful. We say is unlawful. My Lord, can I suggest that one way in which a regime can be tested as to whether it is civil or criminal is, do you need a defendant? And if the defendant is unknown or dead, or indeed, we'd go so far as to say unfit to stand trial and therefore can't put his defence, the court under the Money Laundering Prevention Act cannot seek a civil forfeiture order. There is no defendant if he's dead. There might be overwhelming evidence that the property has been obtained by unlawful means, but that's not possible. My Lords, the position in Antigua, page 784 of the case, paragraph 25, is there's in fact 4 different regimes. There's the regime which this board is dealing with. There's the criminal regime within the same act. And could I take your lordships to that at page 950?
Sorry, where do we see the 4 regimes on page 784?
I'm sorry, my lord. It's paragraph 25, page 784 of the case.
I think they refer to 3 main regimes.
That's why I asked.
My lord, yes, I was about to add in number 4, if I may. It does indeed say 3, and that's wrong, because I think what that's saying is the snapshot at the time of this offence.
Well, perhaps you could just mention the 4th, and then we'll move on. Which is the 4th?
My lord, the 4th is the amendment by the Proceeds of Crime Act 2014, which we say is the way in which civil recovery legislation should be pursued, but that fell outside the time frame. So those 3 is the snapshot.
Has the 2014 amendment superseded this regime, or is this regime sitting alongside?
They run alongside.
That's I thought.
It's a
Yes, thank you.
regime.
Sorry, you're going to take us to?
My lord, I was going to take you to section 20 of the Money Laundering Prevention Act, page 950. This is the section that comes into play if someone is convicted of a money laundering offence. And we say that this is an important section in this case because the respondents did not choose to go under it. And we say that's because he was not convicted of a money laundering offence. But perhaps I can come on to that shortly. My lord, the next point is really the core of the matter is that the terms money laundering activity, and this is paragraph 26 and 27, the terms money laundering activity and money laundering offence, we say are coextensive. Can I also, if I may, deal at the same time, because it covers the same points, with the circularity argument, which is at paragraph 123 of the case, at page 807. My lords, if I may just take you to the relevant statutory provisions. So, money laundering activity is section 2H, which is page 917 at the bottom. In this act, a reference to money laundering activity is a reference to anything done by the person that at the time was a money laundering offence, whether or not the person has been charged with the offence or not, if charged, tried and acquitted, or convicted and quashed and set aside. So then one goes from there to the definition of money laundering offence, which is in section 2.1, and that's at page 911. Sorry, my lords, 909 at the bottom. Money laundering offence means an offence against section 3 and 5 of this act, so that's money laundering. 11A and 18, that's failure to report, opening an account in a false name, and currency reporting, and section 61 is unlawful transactions. And at various sections of the Drugs Act. Now, my lords, can I just take you to page 895, which sets out the sort of issues that this civil court will have to grapple with in order to find that the defendant has engaged in these matters. And if one looks at page 896, section 6, 3, which is relevant to our case, is that it's a question of possession of drugs with intent to supply. And then 4 sets out the defence for that, knowing or suspecting at an A and B. And then section 8 deals with cultivating cannabis, and there's a defence there under subsection 3, knew or suspected, reason to know, and had taken all reasonable precautions. Now, my lords, the reason I say that is crucial to the consideration of this is requiring a civil court to determine the specific elements of criminal offences which involve such matters as mens rea, reverse defences, and not just where there's been a charge or a conviction, but where there's been an acquittal or the Court of Appeal has quashed that conviction. My lord, one ends up in a situation where the jury may have acquitted on section 6.3. As your lordships know, in terms of fresh evidence cases within the criminal sphere, Lord Bingham has said we have to approach the jury's verdict with immense caution. We don't know what elements the jury found to have been proved to their satisfaction, which witnesses they accepted, which matters they were happy with, unhappy with. There is no judgment. There is simply...
The Sphinx-like quality of the jury verdict, isn't it?
My lord, yes. And this act requires a civil court to look beyond the acquittal and to see whether they find the elements of these offences have been made out. And not only that, but where the matter has been quashed, and indeed by Court of Appeal it's easier to understand on what basis it was quashed, but they may in fact reconsider the same issues but simply apply the civil standard. So
it does happen from time to time, certainly in this jurisdiction, where, for example, one's right to an insurance payout or to inherit from someone is affected by the question whether you murdered that person. Now, the person may be either not charged with murder or acquitted of murder on the criminal standard of proof, or the conviction may be quashed. But it doesn't stop the civil court concluding that he did murder them, and therefore depriving him of his inheritance or of his insurance proceeds.
My lord, I think our response is that there is a fundamental difference between a private party pursuing that route and the state seeking to retry a defendant in a civil court when it's either failed or the jury have acquitted. This is dealing with exactly the same matters, exactly the same elements. And if the civil court wanted to go down that route, then one could say that you have to undergo the whole trial again. And of course, the fact that that would be the safest way to deal with it raises problems in itself, because it's retrying him for a matter which the jury have acquitted him on. But there are fundamental elements here. This is also not a question of tort, where there might be murder and then someone brings a civil action when the prosecution hasn't been brought or it's failed. This is the state seeking to give the power to a civil court to determine criminal offences which may have already been litigated. So it would be a problem, we say, in itself. If
How
it was...
does that destroy the analogy? I mean, as my lord points out, I mean, there are ample examples of the state having failed to secure a conviction because it confronts the burden of proof beyond reasonable doubt, and a private individual establishing liability on the balance of probabilities. Why? Because it is the state that seeks to pursue the civil remedy. Why should they be denied the opportunity that a private individual has?
My lord, with respect, it would be extremely distasteful, in my respectful submission, for the state to be able to have a second go with a lower standard of proof, having failed the first time.
Yeah, but the
It's not a
state's
second
seeking,
go.
yes, it's
It's a
seeking a
different
different remedy. Yeah.
Well, my lord, it may be a different remedy, but of course, in order to trigger that remedy, the court has to say, I'm looking at section 2H, the court has to find that the defendant has done something which at the time was a money laundering offence. So it's a specific allegation and a specific list of offences which the court's required to adjudicate on.
Yes, but the sanction is quite different in the two different contexts. I mean, if you're convicted of an offence, you're liable to a criminal penalty. If, on the other hand, you're found on the balance of probabilities to have been responsible for the particular activity, you're not subject to a criminal penalty. So at the moment, I have a slight difficulty in understanding why the state should be deprived of the opportunity that is available to a private individual to pursue a civil claim.
My lord, it doesn't seem that in the civil analogies that the court is bringing back a similar finding to that in the criminal court. I mean, here, the civil court is specifically carrying out a fact-finding and a legal decision-making process relating to specific criminal offences. These aren't torts, but these are, I mean, in the murder analogy that my lord gave, the court's not saying we find that that this person was murdered. It might be unlawful killing.
It might be in the inheritance context. Whether it, in relation to insurance, it probably depends on the terms of the policy.
Well, my lord, is that something that we...
But I mean, for example, let's suppose one killed one's benefactor in a car crash due to negligent driving. I'm not sure that would necessarily deprive you of your inheritance. If you murder him, it certainly does.
My lord, could I perhaps come back?
Yeah,
Maybe something that we can look into. And
Yes, well, let me by all means reflect on it, Mr.
Yes,
Taylor. And,
thank you.
Because it's quite an important point, I think.
Yes, my lord. In terms of the circularity argument, so if one looks at money laundering activity in section 2H, it refers to, this 2H, page 917. Money laundering activity is anything done by a person that's a money laundering offence. Then money laundering offence at section 909 means any one of those particular offences, including money laundering, as section 3. If one then looks at section 3, which is at page 918, it simply says money laundering offence. And then money laundering at section, again at section 21, page 909. Money laundering means engaging in a transaction involving money, receiving, possessing, under B, knowing or having reasonable grounds to suspect that the money or other property is derived or realised directly or indirectly from some form of unlawful activity or is an instrumentality. And then if one looks at the definition of instrumentality above that, instrumentality means a money laundering offence, an offence under that subsection, and a money laundering activity. So one goes around in a circle, and it's simply not possible to define what it is that is prohibited and targeted behaviour. And the danger, particularly in this case, paragraph 130 of my case at 808, is that the freeze order, as I come on to shortly, was the basis was unclear, and the only assertion seems to be, the consistent assertion is that he was engaged in money laundering activity. And so the definition of that phrase is crucial, but it's insufficiently precise. And if one looks at the sort of difficulties that follow on from that at page 809, paragraph 136, and if I take your lordships to the actual section at 19b4, so page 945, it refers to someone who's convicted of a money laundering offence or money laundering activity, or who's charged with a money laundering offence or a money laundering activity, or is about to be charged. And it's clear that there is no offence known as money laundering activity. And we say that underlies and is further proof of the fact that these are in fact coextensive concepts and not separate.
When it speaks of a charge, what does it mean there in relation to money laundering activity?
Well, my lord, that's our point, is that it's that with respect, the Act has got into difficulties because it seeks to both separate out, according to the respondents, the terms money laundering offence and money laundering activity. And therefore it has to seek to justify it in other sections, but it then becomes a nonsense because money laundering activity cannot be charged.
Well, it's just, as defined, a list of offences.
Which is money laundering offences.
Yeah.
So
I'm not sure what it really adds. I'm not sure I've really understood what the words or money laundering activity add to the words in subsection 4A1 or 2, because when you see what money laundering activity means, it doesn't mean the activity of money laundering, which might get you to a non-offence-based definition. It means a series of offences.
Or one series of offences, yes.
I'm sorry?
One of a series of offences.
Yes, that's what it means, yes.
My lord, yes. I mean, I point to that to say that this is we say, is further evidence of the difficulties of seeking to sustain this, we say, artificial distinction between the two, and that these are, in fact, coextensive terms. My lord, if I can deal with the general heading now of the criminal nature of this regime, and that's set out at...
Just before we go there, 19b4, in order for someone in Mr. Williams' position to exercise his right to exclude property from the freezing order, would this subsection be the only subsection that he could invoke?
My lord, this forms part of a complaint, if I can take your lordships to, in terms of a lack of remedy.
No, please focus on my question. Is there another subsection in 19b which he could invoke?
5, I think.
For example, 5. Yes.
Always mainly about people other than the defendant.
Well, my lord, can I ask in this way, and I apologise if I haven't dealt with...
Well, the applicant is not the defendant, so yes, so 4 is wouldn't be his remedy.
No.
5 might be.
And in fact, what we say at paragraph 143 of the case at page 810 is that there is in fact no remedy for someone who is, the freeze order is under section 19(1)(c), which is money laundering activity, because the only people who are covered in 19B, and this is page 9475, and relates to the defendant, is someone who's been convicted of a money laundering offence or charged with a money laundering offence or is about to be. It doesn't deal with someone who has been reasonably suspected to be engaged in money laundering activity. So in terms of section 19, section 19(1), on looks at page 937, this forms part of our complaint about the validity of the freeze order, is that if the freeze order is made under section 19(1)(a) or 19(1)(b), then 19(b)(5) gives jurisdiction to the court to deal with an application to discharge the freeze order. If the freeze order is made under 19(1)(c), suspected of having engaged in money laundering activity, there is no remedy.
Well, until he's joined as a defendant in a forfeiture application under 19B5A3.
Well,
then he gets a look in, doesn't he? You can't forfeit against somebody without joining them to the application, as I understand it.
my lord, yes, but
So then if he's joined, doesn't he then get within 19B5 from the moment of his joinder because of subsection A3?
if, and perhaps, my lord, if I can take you to subsection, section 19A2, which is at page 941. Is that the respondents have 30 days in which to seek that civil forfeiture order. So for 30 days, if they don't apply until day 29, he has no remedy in terms of seeking to discharge the freeze order on his property. And here, of course, we're talking about all of his properties, $700,000 worth, which has been frozen for 30 days with absolutely no remedy at all within the Act.
Yes, that's against the freezing order.
Yes,
but I thought we were mainly here concerned with the forfeiture order, because that's the one that, if you like, permanently deprives him of his property. And am I right in thinking that under 19B5, a defendant or a person who is against whom a forfeiture order is being sought will always be able to exercise the 19B5 remedy, because he will always fall within 19B5A3?
Only from the moment he's joined as a defendant. Yes, my lord. Yes. Yes.
From that later stage.
Yes.
Yeah.
This is a complaint against the freeze order and the right to enjoy property, which can be extensive for up to 30 days. That's the...
Yes, and the freeze order prevents him from disposing of his property in that time.
Yes.
Yes, and you're saying there is no remedy in this Act for someone facing a freeze order for that 30-day period, but you're accepting that after 30 days he will come with, as Lord Briggs says, within 19B5A3. Thank you.
In terms of the criminal nature of the regime, if I can take this somewhat quicker, this is set out at paragraph 102 onwards at the case at page 800. My lord, could I just deal at this stage very briefly with the issue of statutory interpretation of the Act, because I know my learned friends raised the point of interpreting the language of the Act to give best effect to the enactment's purpose and regard to the mischief rule. My Lord, if I can just bullet point this, is that our submission is clearly the long-standing practice of statutory interpretation is to begin with the cardinal rule or the golden rule, simply by reading what the Act says. And here we say the Act says that an order cannot be made unless the person is in effect found to have satisfied the elements of specific offences. And the fact that the government may have intended or now wishes to, that it had intended to include a more general criteria it is not relevant. And my lords, I've handed up the extracts from Craze, but it's page 741. And my lord, if it's page 4 of the bundle in the right-hand corner, but page 741 of the.
You're handing it up for the golden rule.
My lord, yes.
Yes, thank you.
Sorry, it's page 4 of the extract?
It's 741. It's page 4 in the right-hand corner of the bundle.
Yes, thank you.
My lord, even when one moves on to a purposive construction, the mischief rule is applied because there's some ambiguity or lack of clarity. It is, as Lord Nichols said, and this is Craze at page 6 in the right-hand corner, page 735, in Secretary of State for the Environment, the intention which the court reasonably imputes to Parliament in respect to the language used is what's important, not the subjective intention of the minister or the other persons who promoted the legislation. And we say that there are clear indications within the Act that this was recognised as being a criminal statute, although attempts were made to define it as civil. And if one looks at, starts with section 28B, which is page 962, is the proceedings on an application under the Act are civil in nature, except as otherwise provided in this Act. And the marginal note says proceedings on application to be treated as civil. And we say that's a clear indication that this is a criminal act which the legislature is hoping would be civil, but in fact
it's a pretty ambitious claim, is it not? I mean, the actual words of the provision will trump any marginal note. And I mean, this declares that the proceedings under the Act are civil.
My lord, I accept that absolutely.
Except as otherwise provided. Yeah.
Yes. But as the last part of Craze, which I've put in, which deals with headings, and particularly the case of Montilla, at page 12, right-hand corner, page 923 of the book, is that it's clear that whilst they have lesser value than the section itself, that they do have value. And one wonders why it was felt necessary to put in this application is to be treated as civil. If it is civil, it's civil. This is a completely redundant marginal note. My lord, I don't take that point any further than pointing that out. In terms of the nature of the offence itself, one factor that the courts have looked at under this heading is the overlap between the offence, in inverted commas, claimed to be civil, disciplinary matter or a civil offence, and the equivalent criminal offence. And if I can give your lordships just these references, in Eze and the United Kingdom, and this is at page 1273 of the bundle, the offences under the prison rules were classified as disciplinary and domestic law. And at pages 1282 to 83, paragraphs 33 to 35, when considering the nature of the charges, the Grand Chamber noted that the wording of the charges corresponded with the offences in criminal law. That's paragraph 104 and 130. Against that is McCann, which was considering the antisocial behaviour orders. And the court there, and the House of Lords, compared the requirements of the antisocial behaviour order legislation with the Public Order Act. And they rejected the submission that there was a striking similarity, at least in part because there was, even though some elements overlapped, mens rea was not required, and that's at page 1506, as C and F. And in my Lord Kerr's case of Walsh, again there, perhaps I can take your lordships to that. It's paragraph 41.
Sorry, which tab is it, please?
I'm sorry, my lord. It's tab 31, and it's page.
Thank you.
1768.
Which paragraph?
I'm sorry, my lord. I may have given your lordships the wrong reference. Sorry, my lord. Could I just take a moment? Sorry.
Did mention paragraph 41.
Yes,
Yeah.
I'm not sure that was correct, my lord. I apologise. It's
I have to confess that I've completely forgotten what this case was about.
Oh, yes, my lord, sorry. It's page 1765, paragraph 29. And this is a matter where the question was whether the forfeiture procedures were criminal or civil was one of the matters. And at paragraph 29, dealing with the nature of the proceedings, my Lord Kerr said, just by letter D, the allegation made against the appellant does not impute guilt of a specific offence. And of course, this goes back to the point that what's required under what we say are constitutionally compliant civil regime proceedings is unlawful, that the property came from unlawful conduct. And then the reason that it's not a specific offence required, we say, is in part at least that you don't need to identify a defendant. Whereas here, you need to identify a defendant, and from that, the specific offence that he has carried out. In Gale, at page 1713, starts at page 1713, but it's in our submission instructed to read at paragraph 11, page 1721. Again here, dealing with the UK Proceeds of Crime Act, following an acquittal in Portugal and the extent to which the suggestion that this was relitigating the proceedings there is at 1721 paragraph 11, it refers to the initial judgment of Mr. Justice Griffiths-Williams, and he says there, it's 5 lines down, to consider the evidence adduced in the Portuguese proceedings, which resulted in acquittal, is not to relitigate, because what is an issue in these proceedings is not the commission of the specific offences, but whether on the evidence before this court of the material considered by the Portuguese court, together with the evidence available to the Spanish courts, and other material not considered by the courts in either jurisdiction, the claimant has proved that his wealth was obtained through unlawful conduct of a particular kind or one of a number of kinds, which would have been unlawful conduct. So, my Lord, there, in order to fulfil the criteria of the Proceeds of Crime Act seeking to recover the proceeds of crime from unlawful conduct, it's not related to a specific offence, and it's looking much wider than the evidence that's available. Here, the trigger is, look at the evidence that shows that the defendant is engaged in, charged with, or convicted of money laundering activity, specific offences. My Lord, the terms of the Engel criteria at page 801 of my case. If I can deal with say this is the initiation of these proceedings, is that under section 19.1, an allegation is set out by the investigating officer and the supervisory authority that the defendant that there is sufficient evidence for reasonable suspicion that the defendant had committed specific criminal offences. Well, the nature and degree of severity of the penalty. We say it is paragraphs 111 at page 803 of the case.
But the Engel criteria, one is the classification of the proceedings in national law, and you've addressed us on that. Yes. The second is the essential nature of the proceedings, and the third is the type and severity of penalty. And I think you have to look at all three in the round, I think. That's what Lord Kerr, I think, held in Walsh, in the paragraph you referred us to, paragraph 29.
Well, Lord, we'd say the test is at paragraph 105 of the case is what matters is if the factors that are present clearly give them a certain colouring, which does not entirely coincide with that of a purely non-criminal matter. In terms of the domestic classification, I've dealt with that. The nature of the offence, I hope I've dealt with that by saying that what needs to be proved here are the specific criminal offences set out in the money laundering offences. In terms of the proceedings, that's why I say that they are started by, if one has to find an equivalent to a charging decision or an allegation, is they are initiated by evidence from an investigating officer and the supervisory authority that the defendant has committed specific criminal offences. And then in terms of the nature and degree and severity of the penalty, I set out there, my Lord, that paragraph 111, page 803, it clearly involves punishment. There's no question of reparation here or restitution, because the question of benefit is simply not addressed. No judicial discretion. As I say, it becomes, in effect, a mandatory sentence. And there is none of the safeguarding provisions which at page 804, little c, that the European Court identified the sweeping statutory assumptions.
So where are you reading from?
I'm sorry, my lord. 804 of of my case. Little
804.
C at the top.
So paragraph 111, yes.
Yes, my lord. Thank you. That it was these statutory assumptions that were a strong indication of a regime of punishment and a penalty. And indeed, it's because of the potential nature, the potential consequences of these assumptions, and in effect the mandatory nature of confiscation orders under the UK POCA Act, that required Weyer and the Supreme Court there to step in and ensure that the judge can actually refuse to make the order if it's disproportionate. My lord, having dealt with those matters, if I can deal more briefly with the actual grounds and go on to ground one, which is the nature of the freeze order.
Mr. Mishan, in which case did the court say that the judge had to be able to intervene to say that it was disproportionate?
My lord, where? Can I take your lordships to that?
I'd be important.
My lord, it's at page 1658.
Tab.
Tab, thank you, 28.
Thank you.
My lord, this was where false statements had been made about the defendant's employment record and earnings, and he'd obtained a mortgage. He was convicted of obtaining a money transfer by deception, and their prosecution applied for a confiscation order. It wasn't alleged that he had a criminal lifestyle, and by the time the application was heard, the market value of the flat had increased, and the judge increased quite considerably, and the judge made a significant order. The defendant's appeal to the Supreme Court, I'm reading from the head note, my lord, at 1658, the court identified a further issue on which it wished to hear argument, namely the operation of the confiscation order under POCA 2002, which might give rise to an order which constituted a violation of the defendant's right to peaceful enjoyment. And the appeal was allowed. Confiscation order which did not conform to the test of proportionality would constitute a violation of the defendant's right to peaceful enjoyment of his property. So I'm just trying to find the specific paragraph dealing with the refusal to... This, of course, led to the amendment of POCA to ensure disproportionate confiscation orders were not made. But could I just take a moment, my lord? I'm sorry. My lord, I'm sorry. Could I...
Don't worry.
Could I come back?
Yes, by all means.
I am sorry.
No, if the case is important to your submission, then by all means give us the references you want us to look at.
Thank you. The basis on which the freeze order was made, we say this was clearly a penal statute, draconian consequences, and to freeze all of Mr. Williams' property in ex parte proceedings requires precision in asserting the basis, both in the application and ultimately by the judge in granting the order. And here...
Forgive me, where are you in the skeleton then?
I'm so sorry, my
the
lord.
case.
It's page 792 of my case.
Thank you.
And it's paragraph 60 onwards. I'm just summarising the...
Yes.
Yes. Thank you.
And in this case, we say that the bases on which the application was made and indeed granted varied at various stages, was confused, and even now, with respect to my learned friends, the respondent's attempts to justify the basis of the grant of the freeze order is unclear. We say that this is not a matter of form, but it does matter. And it matters because, firstly, the judge must be satisfied of which basis the application is made on, so that he or she can determine whether evidence supports the ground. And if there's multiple bases, and some are wrong, as we say here some clearly are, the defendant doesn't know whether there would have been sufficient evidence on the other grounds to satisfy the judge, or whether it was a combined effect of all the grounds, including the invalid ones. And this is especially so where there's no written judgment. All we have here is a freeze order with the section that was relied upon written on it, but we then have a subsequent judgment by the same judge where he casts doubt and seems to extend the basis on which he granted that earlier order. Secondly, the defendant needs to know what basis it was challenged on. Perhaps that's more of the same point, and it does affect the basis of challenge, the point I raised before about the 30 days under section 19B, with there being no remedy if it's engaged in money laundering activity. My Lord, can I briefly analyse what happened here? And it's at page 793.
Just before you do, can you help me?
Yes.
What happens if there's a freezing order and then no applications made for a forfeiture? Does the freezing order just go on ad infinitum, or does it die?
After 30 days.
It goes after 30 days?
It's simply a 30-day order, yes. I mean, I think the section says that it falls after 30 days.
Yes. I mean, there was some talk in this case.
If what? If there's no forfeiture or if there's no charge?
My Lord, I
thought it was just if there was no charge.
Section 19B.
There's no application for a forfeiture order.
Page 941, sorry, section 19A.
Yes. 942, the freeze order will cease having effect 30 days after it is made, unless by that time he has been charged with money laundering offence or an application for a civil forfeiture order.
But what if there's a charge, and let's say the charge isn't proceeded with, or he's acquitted? What happens to the freeze order? It doesn't cease. Where it is followed by, I mean, I can quite understand that the freeze order is a 30-day protection ahead of charge, but does the Act explain what happens if there is a charge, and then there is never an application for a forfeiture?
My Lord, not that I've seen.
Because my instinctive reaction to your complaining about the disproportionality of a freeze order is that it's only temporary. But I'm just trying to understand what the machinery is that ensures that it's only temporary.
Yes. My Lord, it's not clear, and also at 941, subsection 2A, the wording is unclear, and it indeed reflects 19.1a, is what it means is a defendant is about to be charged. It's, again, a fairly vague phrase, but...
I mean, the obvious purpose of a freeze order ahead of charge is that otherwise he might put his property offshore once he's charged.
Yes.
But I'm looking at the sort of afterlife of the freeze order.
So, my Lord, if he is charged and it's then discontinued with, it would fulfil the criteria of having been charged. And it's disjunctive. It would be or an application for civil. So, my Lord, yes, I would respectfully agree that it seems as though it could go on indefinitely if the charge was not proceeded with and was discontinued. My Lord, in terms of the freeze order, page 793, paragraph 62 of our case, there is now agreement with my learned friend that section 12 of the Misuse of Drugs Act was not a money laundering offence at the time. So I don't need to rely on paragraph 62 and 63 of our case, other than that to the extent it was relied on at any stage in the proceedings by the applicant, or more importantly the judge in granting it, that part would be invalid. In terms of section 6.3 of the Misuse of Drugs Act, can I take your lordships to page 1012? Probation of Offenders Act, and it's section 2, page 1013. Any person who's been convicted on indictment...
Sorry, you're reading from which section?
I'm sorry, Molly, it's tab 5, page 1013,
Yes.
subsection 2.
2.2, thank you.
Sorry, my lord, Mr. Dorset quite rightly points out he was tried in the Magistrates' Court, so it's section 2.1 at 1012. Towards the end of that page, the court may, without proceeding to conviction, discharging the offender conditionally. And, it's the earlier part which sets out the bases on which the magistrate has the power to do that, because of his character, antecedents, age, mental condition, trivial nature of the offence, or the extenuating circumstances. Now,
Well, was he discharged conditionally, or entering into a recognizance, or undertaking to be of good behaviour?
my lord,
He was sentenced to a term of imprisonment on the other charge.
on the others, my lord, the words that the magistrate uses, if I can take your lordships to the specific page in the...
But did he purport to act under this statute?
My lord, no. There's no reference to the statute. What there is...
He founded on a judgment of the court that where an offence which was potentially a more serious offence included within it a lesser offence, you were to sentence under the more serious offence and not under the lesser offence. So looking at what happened here, Mr. Williams was convicted under Section 12, which was a more serious offence than Section 6.3, of which he was also guilty but not convicted. And the only reason he wasn't sentenced under Section 6.3 was because of the ruling by the East Caribbean Court of Appeal in Ortiz.
My lord, with respect, that's exactly the position. It's page 125.
So what's section 2.1 got to do with it?
Well, my lord, if I can put it in this way, is that the only statute that we say the magistrate could have been referring to is this one. The
Did he refer to a statute?
He didn't refer to the statute, no.
No, well-
he
Well,
simply
I mean,
made...
there's a principle of sentencing here that if you have a series of offences, you can impose a sentence. The principal sentence can be imposed on the principal offence.
My Lord, it goes further than that in our submission, is that this is not a question of sentencing, this is a question of ultimate disposal, and that he wasn't convicted of this offence. It's an unusual, in my respectful submission, approach that the Antiguan legislation takes, in that someone could be found guilty but not convicted, but nonetheless that's what the statute says. Now, my Lord,
Well, that's what Section 2 says.
My Lord, yes.
But we don't know that Section 2 is being applied.
My Lord, we don't. Sorry, could I take a moment, sir? My Lord, it's page 125 of the record.
Sorry, 125.
And the justification for it is set out. My Lord Hodgson has summarised the point as to the magistrate's approach to it, but it's page 118 and then 125, the top paragraph is the explanation.
Beginning in relation to the complaint.
In relation to, yes, my Lord, yes. And then under number 1, the defendants are reprimanded and discharged. Now, we say 3 things in relation to that. One is although the respondents take issue with this, they haven't pointed out what other interpretation could have been given to this, and whether there is any other statute that the magistrates could have been referring to. Perhaps...
Does it mean discharged from custody?
Well, my Lord, I think he's going into quite a long term, 5
No,
years.
well, yes, but on that complaint. He's going into custody on another complaint.
Yes. My Lord, could I take you to the list of previous convictions, which I think will assist at page 383.
Thank you.
Lord, I'm sorry, there's 2 records of conviction. 41, thank you, Dr. Dorset, page 41. Sets out the convictions which are noted: possession of cocaine with intent to sell, that's section 12 of the Misuse of Drugs Act. There's no reference there to the section 6.3. There's then the Court of Appeal decision at page 31, the paragraph 1, the appellants were jointly tried, convicted and sentenced for the offences of possession of cocaine with intent to sell, that's a section 12, possession of firearm and possession of ammunition. So there's no reference there to the fact that section 6.3 might be a conviction. My lords, we also...
What does this amount to? I mean, at the end of the day, Section 12 encompasses Section 6.3. That's why Ortiz says impose a punishment under Section 12 because it's the more serious offence. He was found guilty of Section 12, which incorporated Section 6.3. And your only argument for saying that there wasn't a conviction is by reference to the Probation of Offenders Act, to which the magistrate made no reference whatever.
Lord, with respect to...
If Ortiz requires you to not to punish in respect of the less serious offence, then that doesn't mean you haven't been convicted of it.
Well, my Lord, with respect, it does, in this sense, that firstly, the magistrate's decision does not talk about conviction. he talks about discharge and reprimand. It is not listed as a conviction under either the record or the Court of Appeal, and we also rely on the fact that had Mr. Williams been convicted of section 6.3, and it is important for this reason, is the respondents would have been able to rely on section 19.1a in seeking forfeiture. Now, what we understand, and this is at pages 43 to 44 of the bundle, is that there was an initial application for a freeze order in 2009 in March on the basis of section 19.1a. And if one goes over the page to page 44...
On the basis of section 19.1a. Yep.
My Lord, yes. And if one goes over the page, the specific matter that's relied upon at page 44, paragraph 2, is section 6.3 of the Misuse of Drugs Act.
They backed off this order and made a fresh application.
They sought the discharge of the order, and it's dealt with page 385 of the court. Is paragraph 2 relates to refers to paragraph 3, footnote 3, which is then at page 390. Counsel for the authority conceded on an earlier separate High Court civil proceeding concerning the same circumstance the magistrate's decision in support of the said conviction, 6.3, was unclear and did not clearly support a conviction for an offence that can be deemed a money laundering offence. Those civil proceedings were withdrawn.
Sorry, which paragraph are you on?
My Lord, it's page
Footnote
390.
1 on 390.
I'm on 390.
The footnote at the bottom.
I'm so sorry. Thank you. Yeah.
Yes, but to be clear, that what the magistrate was dealing with was the dictum in Ortiz that where one offence includes another offence, it's wrong to be punished for both offences. That's what he was trying to address.
My Lord, yes, and if I can put it this way, is that whether the magistrate was right or not, the reality is there was no conviction in our submission. The reason that that is important is because in order to fulfil the criteria for a freeze order, one has to be convicted of a money laundering offence. And conviction is set out...
I know section 6.3 is a money laundering offence and and for some reason which I cannot understand, the more serious offence, section 12, is not.
Yes.
Or wasn't.
Mr. Taylor, one does have to read, doesn't one, page 125, in its context, which is all about sentence, because it's preceded a couple of pages earlier by a lengthy explanation by the magistrate of the sentencing principles which he's going to apply. I'm wondering if it really is right to, just because he's in a citation, well, in a summary of what he says Ortiz decides, he refers to conviction. He's really saying, I'm not going to sentence you under section 6. I'm just going to discharge you and give you a reprimand, which is perfectly consistent with having been found guilty and therefore convicted. You just don't get a substantial sentence. I just wonder whether this... If you look at Ortiz as if he's talking about conviction, I can understand what you mean, but if you look at it as a sentencing exercise, I'm not sure it follows.
My Lord, I'm grateful to Dr. Dorset, who points this out. It may answer your Lordship's question. Page 125.
Yeah.
The magistrate, in relation to the complaints, directed the Eastern Caribbean Court of Appeal has directed that defendants should be convicted on the offence with the highest tariff.
Sorry, where are we now?
Sorry, my Lord, 125.
Yes, top of the page.
Third line down. The magistrate's understanding of Ortiz is that the defendants should be convicted on the offence.
I can see he says convicted, but if you go back to page 123, this is page 3 of a lengthy section on sentencing.
My Lord, can I put it this way, is that if this is the paragraph which immediately precedes the actual sentences. Yeah. It's stated there that the magistrate's understanding at that point is in relation to conviction, not sentence. There is no reference to sentence there. There is a reference in section 2.1 of the money laundering, sort of our main act, conviction. Sorry, my lord.
Page 1012, probation of offenders
Yes,
act.
no, sorry, my lord, I've given your lordship the wrong reference. Oh no, 2A, yes, to section 2A. Page 912, for the purposes of Part 4A of this Act, a person is convicted if he is convicted of the offence by the court. But then if one looks at the Antiguan Proceeds of Crime Act at 1017, section 4, subsection 2, a person is convicted, if he's convicted summarily on indictment and then over the page, is charged with the offence and is found guilty, but is discharged without conviction. So it was felt necessary there to go further. And again, there's no reference to the Probation Act at that point. It seems to be accepted as a term of art.
So, he is to be taken to have been convicted even though he is discharged without conviction.
My lord, in that act,
yes,
but in the Money Laundering Prevention Act, it refers to simply being convicted, and there's no reference to, under section 2A, to any discharge or other matters. My lord, the importance...
But he is still to be treated as convicted.
In the Proceeds of Crime Act, my lord.
Yes, but I mean, if he's convicted under the Proceeds of Crime Act, does he not stand convicted for any purpose?
My lord, he wasn't convicted under the...
But was he not discharged without conviction?
In relation to the Misuse of Drugs Act.
I see.
So, my lord, the short point is this, and I hope your lordship will forgive me if I'm labouring this, but...
No, not at all.
If section 19.1 is to have any meaning as a lawful procedure, then it simply cannot be relied upon to say, well, we haven't fulfilled all the criteria, but it seems obvious on the evidence that he's nonetheless falls within the sections. The legislature in Antigua has seen fit to specify specific offences, and indeed, when Section 12 of the Misuse of Drugs Act was not included, it saw fit to amend the Money Laundering Prevention Act in order to include it. Yeah. So the list is important. The list is important not just from the legislator's point of view, but from the defendant's point of view, to know what behaviour is prohibited and what behaviour is likely to result in a forfeiture order. And at the end of the magistrate's court proceedings, and seeing the record of conviction, and seeing the Court of Appeal's reference to it, my submission is that it simply would be unfair and wrong to put any interpretation on this, particularly as the respondents themselves seem to have conceded by seeking a discharge of the first freeze order application on this basis, that this was not an offence which was a money laundering.
I can see it might be wrong. I'm not sure if it's unfair in the circumstances of this case, because you have a clear finding by a criminal court that he was guilty of an offence under Section 6.3, which is a finding by a criminal court of money laundering activity. But it may not be a conviction. It may not be a conviction of a money laundering offence for the reasons you say, because the magistrate appears to be treating Ortiz as requiring him to convict of the offence with the highest tariff.
My Lord, 2 points, if I may, in responses. One is that whether it's activity or offence, we say they're coextensive, and so therefore it has to be one of the specific offences. One can't get round it by saying, well, it was money laundering activity in its widest sense, but it didn't fulfil the criteria of the specific offences that are listed. And that's why at the start of these proceedings...
Sorry, it is being said that they fulfilled the criteria of Section 6.3. I've become a little bit adrift from your argument, because for a freeze order under Section 19.1, you don't need to have a conviction because of C. You just need to be suspected of having engaged in money laundering activity, which Mr. Williams undoubtedly was. So the freeze order is obtained on that basis, not on the basis of a conviction. You've, to my mind, rightly shown us that there wasn't a conviction. But then when it comes to civil forfeiture, the relevant test, as I understand it, is in Section 20, capital A, subsection 2, which is that the High Court shall make a civil forfeiture order if the court finds that it's more probable than not that the person in respect of whom the freeze order was made had, at any time, not more than 6 years before the making of the application for the civil forfeiture order, engaged in money laundering activity. Now, applying that test, in light of the conviction for the offence under Section 12, which comprehended Section 6, the offence under Section 6.3, it seems clear that the court could conclude on that it was more probable than not that Mr. Williams had engaged in money laundering activity.
Well, my Lord, if one steps back and says, what is money laundering activity? We say it's coextensive with the money laundering offences which are listed. Section 12 is not within that.
No, but Section 6.3 is, and it's quite clear from the findings of the magistrate that Mr. Williams had engaged in conduct that met all the criteria for an offence under Section 6.3, even though he had not been convicted of that.
My Lord, I accept that. The appellant's argument is that if the freeze order was granted on the basis of Section 19.1a, and that was based on the fact that he was convicted of Section 6.3, the freeze order is invalid. One can't backdate the position retrospectively to say, well, he was guilty of something anyway, and it doesn't matter what subsection under Section 19.1 goes on. And my Lord, can I just briefly take you through the history of matters very briefly, is that the freeze order itself at page 937 sorry, my Lord, 385. The judge says that, and this is the application for the discharge of the freeze order. The judge says variously, paragraph 1, the discharge of the freeze order was made under Section 19.1a. That would be for conviction.
Where's this paragraph?
It's page 385, paragraph 1.
385.
So this is the same judge that made the freeze order, now dealing with the application to discharge.
Discharge is made under 19.1a.
No, the freeze order was made under 19 brackets 1a is simply the ability to have an ex parte application.
Do we have the freeze order itself?
But in paragraph 2 it says the order was actually made under 19.1c, on suspicion.
These are the Where's the freeze order?
Page 202, I think.
57, my lord. 202, sorry.
Well, paragraph 1 on 385 refers to an order made by the High Court pursuant to section 19.1a, 19.1a and 19.4 of the Act.
Yes, so my lord...
But paragraph 2 refers to 19.1c.
Yeah.
Yes.
So, my lords, if I could just briefly take you through it. So the first paragraph says it was based on conviction.
Sorry, if we're going to page...
Sorry, my lord, this is page 385, paragraph 1.
Yes.
The first paragraph, section 19.1a, which is conviction, that can only be section 12 or section 6.3. So if that's right, we say that's invalid. The paragraph 2 says it was applied for under section 19.1c, which is engaged in money laundering activities.
Is that paragraph correct or incorrect, paragraph 2?
Well, my lord, one of the difficulties is the application was made under various headings.
Well, look at page 152, please. That is the order of that's the application of 9th June 2009. And in the third paragraph, the claimant claims against the defendant for an order under 19.4a. You see that?
Sorry, my lord, page, I'm so sorry.
152.
Yeah.
And
That's the June.
further down, the application without notice refers to various sections, and then it says pursuant to section 19.1c.
Yeah.
Yes. And if my lord looks at paragraph 71 of my my case 795, I set out the basis of the application there. It was made under section 91c, but the narrative referred to section 6.3.
But he was charged with section 6.3.
My lord, yes, he was charged, but by this stage, things had moved on and he'd been reprimanded, and it would be unfair in our submission to rely on a charge where matters have moved on considerably.
But he'd been found guilty.
Why can it possibly be unfair when he was convicted of an offence which incorporated section 6.3? You may be right, he wasn't convicted of section 6.3, but I can't follow your submission at the moment.
The application seems very precise, reliance on section 19.1c, suspicion of money laundering activity. You accept that section 6.3 constitutes money laundering activity. He was convicted of an offence under section 12, which comprehends section 6.3, i.e. money laundering activity. And as I observed before, under section 20 capital A, subsection 2, for the forfeiture order, all that had to be shown was on the balance of probabilities he had engaged in money laundering activity, which on the judgment against him in the criminal court he undoubtedly had.
Well, my lord, I would go back to the point that one has to be precise in the application and the grant. And perhaps if I could just take your lordship through the judgment at page 385, because it does represent the conclusion, the confusion. Is that, as I say, paragraph 1, section 1a, paragraph 2, section 91c, paragraph...
But I mean, as between those two, when one looks at the application itself, it seems clear, doesn't it, that the accurate statement is that in paragraph 2, and that insofar as section 19.1 little a is referred to in paragraph 1, that's just a slip.
My lord, it may or it may not be, and this is the difficulty we have. Could I just continue and it may...
Yes, of course.
Well, since you've got less than 10 minutes left, Mr. Taylor, I think we'd better let you forge ahead.
So in terms of paragraph 396, and this again, it throws into complete disarray the basis on which it was ordered, is paragraph 39 the judge says the source of the funds for the acquisition and development of the properties are sufficiently unsubstantiated so as to give rise to reasonable suspicion that the defendant engaged in statutorily prohibited activity. So there, the judge seems to be relying on property which was bought outside of the 6-year period related to 2002 as part of the basis on which the freeze order was granted.
Right.
My Lord, paragraph 396, again at 38, is the judge refers there to, by virtue of section 19(1)(c) of the Act, the claimant replies on the historic activities of the defendant, including the conviction and prior property acquisitions, to found the suspicion. There it looks as though the conviction that was being relied on was the previous drugs matters, which were in 1999, rather than the specific matters here. My Lord, in terms of the making of the civil forfeiture order itself, page 635, is the judge there paragraph 28. There's two paragraph 28s, it's the first one. He was convicted of 2 serious offences, and so there the error again is in relation, we say, in relation to 6.3. My Lord, we say that this is so vague and confused, and that the freeze order and indeed the civil forfeiture order may have been granted on a wholly invalid basis. Can I deal very briefly with the constitutional challenges? Because these, as I say, they may be less contentious if your lordships find that these are criminal proceedings. And they go from page 804, paragraph 112 of my case. And the central feature is at paragraph 115. The need for precision in criminal statutes is that, in part, that a person should know what act is going to lead to an offence, and we say that there's lack of precision here. Your lordships have the references there to the various contradictions, we say, and then at page 811, the criminal standard of proof, this is paragraph 146, presumption of innocence, the reverse burden and costs are all set out there in detail. Could I just address your lordships finally on disproportionality, which is paragraph 186. We say that it's not necessary to go so far as to say this amounts to inhuman, degrading treatment or punishment. It's clear that the authorities will strike down legislation that is considered to be disproportionate and arbitrary, and it applies to property as well as bodily impairment. And of course the Court of Appeal dismissed Dr. Dorset's submissions on Article 7 on the basis that it didn't apply to property, which we say is wholly wrong and not borne out by the authorities.
Yes.
If one looks at the balancing exercise that at page 820,
Sorry, page?
Sorry, page
Yes.
820
Yes, got it.
of my case, my Lord, paragraph 195. Having accepted that civil recovery is a legitimate legislative objective, but that it does interfere with fundamental rights, the approach of the courts have been to ask whether, as I said at the outset, this is precise and clear and proportionate. And the difficulty here is that there is no reference to benefit. There is no reference to culpability, as I said earlier, and the consequence is that there's an unlawful interference with judicial discretion, as I set out at paragraph 198 onwards. In terms of my final submissions on this, at page 822, paragraph 204,
Yes?
it is at paragraph B, if I can start there, that in effect it's mandatory punishment, and C, it unlawfully removes the discretion. And in paragraph 206 of my case, it's submitted that this imposition of the punishment for money laundering, it is punishment in the sense that it goes way beyond the issue of restitution, that this is a classic issue for judges to be able to deal with, and that is the issue that the Supreme Court struggled with in Weyer, and which led to the amendment of the Proceedings of Crime Act. My Lords, unless I can assist you any further at...
Thank you very much indeed, Mr. Taylor. Dr. Dawson? Nice to see you here again, Dr. Dawson. Thank you very much indeed. Now, Mr. Simon.
Thank you, my lords. Let me state at the outset, my lords, that I am going to be dealing specifically with the CFO regime as it has been laid out in the Money Laundering Prevention Act. My junior learned friend, Ms. Atezi, will deal with the constitutional issues which have been raised by the appellant.
Yes.
Now, my lords, the application to freeze the properties of the appellant. Oh, before that, I have actually got handed out to your lordships a bundle which contains the procedural chronology and factual matrix,
Yes.
as well as various amendments which were made to the legislation. And I think this should be of some assistance to your lordships. And I will be referring to that because it makes things a little simpler in respect of following. But in respect of the application to freeze the properties of the appellant, this was made on June 9, 2009, and it appears at page 152 of the record. What is very clear is that the application was made under or pursuant to section 19(1)(c) of the MLPA, short for Money Laundering Prevention Act. And that reads, where a person referred to in this part as a defendant is suspected of having engaged in money laundering or activity, the supervisory authority may apply to the High Court for an order freezing property in which there is a reasonable suspicion that the defendant has an interest. I think it has been pointed out, and your lordships have noted, that the initial application by the supervisory authority was under section 19(1)(a).
That was discharged by Justice Harris.
That was not only discharged by Justice Harris, but it was discharged on the application of the supervisory authority.
Yes. Which may suggest that you had concerns about what the magistrate had said.
Indeed, and we will come to that a lot.
Yes.
So, to make it very abundantly clear, we therefore proceeded not upon a conviction of money laundering offence, but that the person is suspected of having engaged in money laundering activity. Now, what is money laundering activity? And this has been defined in section 2H, which is at page 917. That's 917 of the authorities.
Yes.
And it reads, in this act, a reference to money laundering activity by a person is a reference to anything done by the person that at the time was a money laundering offence, whether or not the person has been charged with the offence, and if charged, A, has been tried, or B, has been tried and acquitted, or C, has been convicted, even if the conviction has been quashed or set aside. So I am respectfully submitting that money laundering activity does not necessarily mean that there must be a conviction for a money laundering offense. The person simply has to be charged, tried, or the evidence itself, the circumstances, clearly indicate whether the individual has been charged or not. The circumstances clearly indicate that there has been a sufficient evidence to ground a money laundering offense. This is the first point which I wish to make. So when we look at page 42 of the record, we will note that the supervisory authority had initially gone under limb A, indicating that the individual has been tried and convicted, but that was discharged on the initiative of the supervisory authority. Now let me take your lordships to the issue of money laundering offence within the context of this appeal. If we go to section 2.1 of the MLPA, and that should be on page 909, we see that money laundering offence means an offence against various sections of either the MLPA Act, the Proceedings of Crime Act, as well as the Misuse of Drugs Act. We concede that section 12 of the Misuse of Drugs Act, which deals with possession with intent to sell, was not at that time a money laundering offence.
That presumably was an oversight.
Sorry, Bilal?
That presumably was an oversight.
Because it was then amended.
Yes, if you make the lesser charge
yes,
a money laundering offence, it's strange not to make the greater charge.
It did. But section 6.3, under which the appellant was charged, deals with possession simpliciter. And clearly, if one is charged and convicted under section 12.1 of the Misuse of Drugs Act, that deals with possession with intent to sell. So possession impliciter is included within that section. So there does not necessarily have to be a charge simply dealing, or conviction dealing with possession simpliciter. So we say that having been convicted of under section 12.1 of the Misuse of Drugs Act, clearly there was unlawful possession of the controlled drug, because you cannot sell something that you do not have possession of.
But the 6.3 It wasn't possession simpliciter, but it was possession with intent to supply.
To supply.
Yes. So it may not matter, but the relationship between 6.3 and 12 isn't entirely clear.
I will accept that, Millard, because I guess sale means there has to be some exchange of monies.
Well,
supply simply means that
you could give it to someone.
I'm giving it to someone.
I see.
Who knows, that individual who I give it to may very well eventually sell. But the transaction between myself and that individual is that I am supplying him
But
and not selling. So there is no financial transaction between the two.
But we're not dealing with possession simpliciter under Section 6.3.
Under 6.3.
But a sale is a form of supply, presumably.
Yes.
Yes.
And presumably it's the treated as the graver offence because
getting money.
You're using the drugs to make money. It's an aspect of a business,
It's an
as
aspect
opposed to possibly just supplying friends.
The important thing, the essential thing, is that you're in possession of the drugs. Unlawful possession of the drugs.
Well, I think the intent to supply is also an important thing if you're looking at Section 6.3, but I think this debate rather reveals why the offence under Section 6.3 is taken to be included and lesser than the offence under Section 12.
Did Millard. Now, in respect of the complaint under Sections 6.3, he was reprimanded and discharged. And the appellant's position is that since he was reprimanded and discharged, he was not convicted. And the magistrate's rationale appears at page 25 of the record. At page 27 of the record, where he quotes the case of Ortiz versus the police.
Yes.
We first of all contend that the magistrate's interpretation of Ortiz was wrong.
Have we got Ortiz in the bundle?
Yes, we've got it, Millard.
Good.
It's on tab 11 on the respondent's bundle.
Thank you. Oh. Is there a page number for that?
Yes.
Thank you.
Now this is, if we look at the page 214, letter G of that judgment.
Sorry, we're going to tab 11 of the Respondent's bundle.
214, yes, Millard, of the respondent's authorities.
Thank you. Paragraph.
G, at G, which is at page 214.
Sorry, what's the electronic page number?
This is what the court says. However, since the sorry.
I think it's quoted in Mr. Taylor's case in the footnote, as I recall.
Yes, it's not in the appellant's bundle.
Well, it's 3103 in the electronic.
3103 is the beginning of the case, but I'm looking for the relevant paragraph.
Which paragraph do you want to...
Paragraph G, which is on the penultimate page of the judgment. And all the court says there is this. However, since the second offence included the first offence, it was wrong to have punished him separately for both offences. Accordingly, we must set aside the fine and alternative sentence of imprisonment imposed upon him with respect to the first sentence.
I mean, the short point really is this, that the Caribbean Court of Appeal is suggesting there shouldn't be two punishments where one offence includes another. But it is not saying that you cannot
must not convict for the second offence.
And when the magistrate said convicted, he really meant punished.
I would want to think so, my lord.
Well, that's what the case says, and
Yes.
it's a little difficult to think of somebody who's been found guilty for something and then not convicted.
Indeed. And normally what happens is that you convict, but then you make your sentence, whether it's imprisonment or
Yeah,
fine,
right.
your imprisonment to run concurrently with respect to the sentence of the first offence, so that it's incorporated in it and it's not a separate term of imprisonment or an additional term of imprisonment. And that is what Ortiz really is indicating.
I rather had the impression that the magistrate read too much into Ortiz, because Ortiz does seem to be focusing specifically on sentencing, but the magistrate seems to have treated this as an authority which meant that there shouldn't be a
There
conviction.
should not be a conviction.
So I think that's your point, Mr.
That is-
Simon. That's your point. You
that is my
say
point.
the magistrate misunderstood it.
That is my first point. There was a misunderstanding. The second point which I wish to make is that my learned friend, on behalf of the appellants, has suggested that the magistrate reprimanded and discharged the appellant under the Probation of Offenders Act. What I'd like to do is to invite the court to look at the Probation of Offenders Act at page 1012. We look at section 2.1, which is pellucid. Where any person is charged before an inferior court of summary jurisdiction with an offence punishable by such court, and the court thinks that the charge is proved, but is of opinion that having regard to the character, antecedents, age, health, or mental condition of the person charged, or to the trivial nature of the offence, or to the extenuating circumstances on which the offence was committed, it is inexpedient to inflict any punishment or any other than a nominal punishment, or that it is expedient to release the offender on probation, the court may, without proceeding to conviction, make an order, either A, dismissing the information or charge, or B, discharging the offender conditionally on his entering into recognizance. The first point is that that section was never mentioned by the magistrate. The second point is that there were no issues of the appellant's character, age, antecedents, health, mental condition, or extenuating circumstances which have been identified in the judgment. And clearly, the charge did not relate to a trivial offence. So I submit that it is very clear that Section 2.1 of the Probation of Offenders Act cannot apply to the appellant. And therefore, when the magistrate reprimanded and discharged, that was not being done under the Probation of Offenders Act. Simply was a misunderstanding by the magistrate, and clearly we can see that the offence of Section 6.3 was proved.
Well, although he didn't refer to this section, is there any other provision by which he could have discharged the...
None whatsoever.
So that was a complete misapprehension on his part, then, was it?
Total misapprehension, with I say with respect.
Do magistrate sentencing powers in Antigua not include an absolute discharge?
I believe that they have to refer to the Probation of Offenders Act. Because normally what will happen is that having found the individual guilty, if it's a lesser offence, they would give a sentence of imprisonment which would be incorporated in respect of the larger or heavier sentence.
So, But you're accepting that he misunderstood Ortiz.
That is my opinion.
And are you accepting also, in accordance with Mr. Taylor's submission, that he didn't convict of Section 6.3, hence the application under Section 19.1c?
Was withdrawn.
No, 19.1a was withdrawn. 19.1c was proceeded with.
19.1, yes, was proceeded with. I think what happened was that the DPP recognizing that and accepting it at its face value, that there was not a conviction, withdrew it and went on the 19.1c.
And are you asking us to proceed on that basis?
And I am respectfully submitting that we should proceed on the 19.1c.
You say that it's perfectly reasonable to suspect something that's been actually proved.
Yes. It may not have been convicted.
Might be difficult to
Right. But it does put you on the skid so
suspect
far as
something that has been proved.
May I?
Yes.
I don't think I got clearly exactly.
No, I was just making the observation about my Lord's comment. It'd be somewhat difficult not to suspect something which has been proved.
I was purely putting it gently.
Yes, well,
Yes.
as is your characteristic, yes. Right, Mr.
Now,
Salmon.
I need now to take your lordships to the question, what was the money laundering activity in which the appellant was suspected to be engaged in, which allowed for the freeze order application? And I take your lordships to section 2H of the Money Laundering MLPA, Money Laundering Prevention Act. Which appears on page 917.
Sorry, which page, please?
Page 917.
917, thank you.
And it provides that in this act, a reference to money laundering activity by a person is a reference to anything done by the person that at the time was a money laundering offense. Whether or not the person has been charged with the offense, and if charged, has been tried, or B, has been tried and acquitted, or C, has been convicted, even if the conviction has been quashed or set aside. Now, the grounds on which the supervisory authority had held suspicions of the appellant being involved in money laundering activity was based upon the affidavit of Ronald Christopher, which was filed in support of the freeze application. And I refer your lordships to pages 160 to 162 of the record. That's at 158, sorry, 158 to 161. And we look at paragraph 7 specifically of that affidavit. I believe that Ahmed Williams has engaged in money laundering activity, and the grounds for holding that belief are inter alia, found in the decision of the magistrate in the case of Commissioner of Police versus Lester Charles and Ahmed Williams, a copy of which is exhibited hereto and marked RC1. And the relevant facts of the case include the following. And can we go to E? Because A, B, C simply deal with the issue of the convictions and discharge. But if we go to C, to E, sorry, the facts of both Section 12.1 and Section 6.3 offences are set out on pages 3 to 6 of the exhibit, particularly in the magistrate's quotes of various witnesses, and he mentions the various police officers who actually gave evidence in the matter. And I would direct your lordships to pages 6 and 7 of the record, where the magistrate in his decision
Sorry, page
6-7 of the record.
607.
Yes, my lord.
Thank you.
That is where the police officers, the evidence of the police officers, were produced by the magistrate. First, we have the evidence of Corporal Coffey, who said this: I saw the defendant, Ahmed Williams, who was sitting at the back. Well, before that, he says they were on a by road west of the Wesleyan Holiness Church, where they saw a vehicle, a white motor car, parked on the right side of the road with 3 persons in it. He then says, I saw the defendant, Ahmed Williams, who was sitting at the back of the said car on the right side, come out from the back right door and ran in a western direction in an old abandoned house, and in doing so, a white package fell out of the car as he fled from the car. Lester Charles was the other defendant, also was the driver of the said car, was caught attempting to come out of the said car with 1 foot in and 1 foot out. He was kept in custody next to the car while the officers who went in search of Ahmed Williams brought him back to the car and handed him over to me. I took up the package that fell outside the car and showed Ahmed Williams and told him this package fell out of the car while he was exiting the car. While searching the back seat of the rent-a-car where Ahmed was sitting, I found 2 more packages suspected to be the controlled drug cocaine. And while searching between the driver's seat and the passenger seat at the front, I found 1 black 9mm pistol with a loaded magazine with 7 rounds of ammunition. And on the floor in the passenger seat, I found a white plastic bag containing a quantity of EC money. I showed them the monies, the substance, the firearm, cautioned them and asked them who they belong to. Ahmed and Charles say they don't know anything about it. I also showed them the ammunition, and they said they do not know anything about it. The monies, the substance were given in evidence. We look to see what Officer John Henry says. We approached the said vehicle, and the driver, who I now know as the defendant, Lester Charles, was apprehended right at the said vehicle. I observed when the search was carried out that 2 other white packages laying on the back seat, along with them, was a large quantity of US currency. I observed when Corporal Coffey showed that white plastic package that fell in the gutter, along with the 2 in the back seat and the black pistol. They both denied, saying they did not belong to them. We go now to Charles Ralston Williams. On the 2nd November 2007, about 6:35, on my way out back to the shop. Now this Charles Ralston Williams was the owner of the shop where Ahmed Williams ran to. All I could see was the 2 legs on my shop counter. I then looked up and realized that it was somebody who I knew. All I hear him say is, "Cocky, police are running," meaning the police are running after me. And before I could say anything, he was off the counter, past me, and headed for the said bedroom. Then I went back into the shop. Minutes later, a plainclothes officer came up to the shop. After that, the police came over the counter, went inside the bedroom, and brought out a person whom I had known before as Ahmed Williams. They took Ahmed Williams from under the bed. Now, somewhere in the evidence, it will be also indicated that the car was being taken for repairs to be done by Ahmed Williams. So we ask ourselves, why would a car being taken for repairs contain packages of cocaine US money and EC money. And why the police, having found that in the vehicle in which the defendant, Ahmed Williams, along with two others were, why would Ahmed Williams deny that he knew anything about either the ammunition, the firearm, or the drugs? It was on this basis that this evidence was taken before the magistrate, and we contend that that constituted money laundering activity because it was evidence which could be based, it was evidence which would have led to the charge being preferred against Ahmed Williams and his conviction. So that the important point is that he doesn't have to be convicted for him to have engaged or found to have been engaged in money laundering activity. We say the evidence shows clearly, even the police interception, that they had reasonable grounds for suspecting that the appellant was involved in money laundering activity. It was on that basis, my lords, that the freeze order was made pursuant to section 19B5 of MLPA, and that can be found at page 947. Of the authorities.
Yes.
Was it 937? Is it 19.1c?
It's 19.4. What section it is?
19.1c.
19.1c.
That's 9337.
It's 37. 47. Yes. So where a person referred to in this part as a defendant is suspected of having engaged in money laundering activity, the supervisory authority may apply to the High Court for an order freezing the property. Now, the freezing of the property is automatic for 30 days. And in fact, the section makes it very clear. If we look at section on page 942, which will give you subsection 6, subsection 2b. The freeze order will cease to have effect.
Sorry, 942.
942 of the authorities. The freeze order will cease to have effect 30 days after it is made, unless by that time the defendant has been charged with money laundering offence or an application for civil procedure order or civil proceeds assessment order has been filed.
Right. Well, let's take a break now and we'll sit again at 2 o'clock.
Appreciate it.